I read the fine print the way other people read the news. Every morning, first thing, before the coffee finished brewing. That's the kind of person I am. Always have been. My wife used to joke that I'd read the terms and conditions on a birthday card if one came with them. She wasn't entirely wrong. I spent 22 years in data security. Not the flashy kind, not the guys who get called into boardrooms to announce they've stopped some international cyber attack while everyone claps. The quiet kind. The kind who builds systems that nobody notices until the day everything falls apart and suddenly everyone's asking why the logs weren't backed up properly, why the access controls were misconfigured, why nobody flagged the anomaly 6 weeks ago. I flagged anomalies. That was my job. And for 22 years, at a mid-sized financial services firm just outside of Mississauga, I did that job without a single serious incident on my watch. Not one. My name is Everett. I was 51 years old when this happened. I want you to remember that because it matters. It matters in ways I didn't fully understand until it was over. The company I worked for handled back-end payment processing for a cluster of credit unions and smaller regional banks across Ontario and into Manitoba. Not a household name. The kind of company whose name you'd never recognize, but whose systems quietly touched your money at least a few times a week. We processed billions annually. The margins were tight. The regulatory obligations were not. I'd been there long enough that I remembered when the server room was in a converted broom closet. I'd helped build what became a genuinely solid infrastructure, and I was proud of that in the way you're proud of something you know is real, not because anyone handed you a trophy, but because it worked day after day for more than 2 decades. Then my company was acquired. The acquiring firm was based in Calgary. Larger than us, newer, backed by private equity, and moving at a speed that made everyone in our Toronto area office nervous. They were good at one thing above everything else. They moved fast and worried about the details later. Or not at all. The new head of technology, my direct superior after the merger, arrived in our office on a grey Tuesday in February. His name was Shelton. Late 30s, sharp dresser, the kind of guy who walked into a room and immediately started rearranging the furniture in his mind. He had an MBA and a way of talking that made everything sound like an opportunity and nothing sound like a risk. Our first meeting lasted 40 minutes. He spent 35 of them telling me about his vision. He used the word velocity 7 times. I counted. I tried to listen with an open mind. I genuinely did, but there was something in the way he answered my questions, or rather, didn't answer them, that settled in my chest like a stone. When I asked about the transition plan for the legacy audit systems, he said we'd figure it out as we go. When I asked about pipe-hitter compliance timelines for the newly merged datasets, he said, that's what we have legal for. I nodded. I didn't push. But that night, I went home and I did something I hadn't done in years. I pulled out my employment contract, the one I'd signed with the original company, the one that had transferred over under the terms of the acquisition, and I read it again. All of it. Every clause. There was one I'd negotiated back in 2009 that I'd nearly forgotten about. Section 14, subsection C. It was dry language, the kind that makes your eyes glaze over if you're not paying attention. But what it said essentially was this. In the event of any regulatory investigation or legal proceeding arising from a breach of security or data handling protocols, I had the right to retain and produce my own copies of any audit documentation I had personally generated, regardless of company data ownership provisions, for the purposes of my own legal defense or cooperation with regulatory authorities. I'd pushed for that clause after reading about a case in the US where a security officer had been made into a scapegoat after a major breach. His company had locked him out of his own records. He had nothing to defend himself with. I was not going to be in that position. When I'd originally added that clause, my then manager had looked at it, shrugged, and said, "Sure, whatever you need, Everett." It had seemed theoretical at the time. A precaution for a scenario I hoped would never come. I started making copies of my audit logs the next morning, not because I knew something specific was wrong, but because Shelton had a way of making me feel like something specific was about to be. The first 8 months after the merger were manageable, uncomfortable, but manageable. Shelton was pushy, impatient with process, and had a habit of approving access requests that should have gone through a proper security review. I documented everything. I flagged everything through the proper channels. In writing, always with a timestamp. He would acknowledge receipt, override my concerns, and move on. Sometimes he'd CC the new CTO on the override, which was his way of telling me the decision had been blessed from above. I kept copies of all of it. The incident that changed everything happened in October. A third-party vendor, a small analytics firm they brought in without going through our standard vendor security assessment, was given read access to a segment of our transaction database, not write access, just read. But the segment they were given access to included fields that, when combined with other data the vendor already held from another client, could potentially be used to re-identify individual account holders. Under Pipeheader, that was a problem. A serious one. I wrote a formal incident report. I sent it to Shelton, to the CTO, and to the privacy officer, who, since the merger, was a part-time consultant named Bridget, who worked Tuesdays and Thursdays. I sent it on a Monday. By Wednesday, I had a meeting request from Shelton. Just the two of us. I walked into that meeting expecting a difficult conversation about timelines and remediation steps. What I got was something else entirely. He had my incident report open on his laptop. He'd highlighted a section. He turned the screen toward me and said, "This language here, re-identification risk. Do you understand what happens if this gets to the office of the Privacy Commissioner?" I said yes. I said that was rather the point. If we had a potential breach, we had an obligation to assess it and potentially self-report. He closed the laptop. "Everett," he said, and the way he said my name had a particular weight to it. "I need you to think about what you're doing here. We're 6 weeks away from closing a deal that's going to double this company's revenue. A filing with the OPC right now, even a voluntary one, freezes everything. Do you understand what that means for the people in this building?" I told him I understood the business implications. I told him I also understood our legal obligations. He leaned back in his chair. He looked at me the way people look at something stuck on the bottom of their shoe. Then he said, "I think maybe you're not the right fit for where this company is going." I asked him what that meant. He said we'd talk more next week. I went home that night and I backed up every audit log, every flagged incident report, every email chain, every access override I documented. I uploaded them to a personal encrypted drive, entirely within my rights under Section 14C. My wife asked me why I look like that. I said, "Because I think I'm about to get fired for doing my job correctly." She put down the dish towel she was holding. She's not a person who alarms easily. She's a nurse. She's seen things that would make most people's knees give out. But she looked at me with a steadiness that I needed right then and said, "Then make sure you can prove it." I already was, 2 weeks later, on a Friday afternoon. They always do it on a Friday. I was called into a meeting with Shelton and an HR representative I'd never met before. The HR representative was from the Calgary head office. She'd flown in that morning. That told me something. The termination letter cited performance issues, specifically failure to meet departmental goals, poor cross-functional collaboration, and, this one still makes me shake my head, repeated failure to align with company values. 22 years. Not one serious incident. The severance offer was 6 weeks. In Ontario, after 22 years of employment, that was not just low. It was, in the opinion of the employment lawyer I called that same evening, potentially in violation of the Employment Standards Act, and certainly inconsistent with what common law would suggest a court would award. The employment lawyer's name was Marguerite. She came recommended by a friend. I explained the situation. She asked me a series of questions. Then I told her about Section 14C, and I told her about the copies I'd made. She was quiet for a moment. Then she said, "Everett, before we talk about the wrongful dismissal claim, I want to ask you something. You documented access overrides. You documented a potential PIPTA breach. You flagged it formally, and you were terminated 2 weeks later. Is that accurate?" I said it was. She said, "And you have copies of all of this in your possession legally?" I said I did. She said, "Good. Because what you're describing isn't just a wrongful dismissal, it may also be a reprisal against a whistleblower under the PIPED framework. Those are two very different conversations. I hadn't slept well in 2 weeks. That night I slept fine. The next month was methodical. I'm not going to pretend it wasn't also exhausting and frightening. My wife and I talked every night about the finances. We had a mortgage, we had her mother in a care facility in Brampton, we had a son finishing his second year at Waterloo. The loss of my salary was not abstract, it was real and it was immediate. But I kept coming back to one thing: I had not done anything wrong. I had done everything right, and I had the paper trail to prove it. Marguerite filed first with the Ontario Ministry of Labour regarding the severance underpayment. Standard procedural move. It put the company on notice and started a clock. Then she sent a formal letter to their legal counsel outlining the nature of the potential whistleblower reprisal claim and the evidence supporting it. I was later told second-hand through the process that when their in-house counsel received that letter and learned about Section 14C and the documentation I held, the response from their legal team was not measured. One of the lawyers apparently told Shelton that the termination, as structured, was going to be extraordinarily expensive for the company to defend. Shelton, from what I understand, was not pleased to hear this. Here's the thing about people like Shelton. They're very good at reading a room when everyone in the room wants what they want. They're very bad at reading a room when the room stops cooperating. The company's initial response was to offer an improved severance, still below what Marguerite and I believed was appropriate, but better than 6 weeks. We declined. Then the third-party vendor situation got more complicated, and not because of anything I did. It turned out that Bridget, the part-time privacy consultant, had been keeping her own records. When she learned I'd been terminated after raising the vendor access concern, she contacted the Office of the Privacy Commissioner independently. She had no obligation to tell the company she was doing so. She just did it. I didn't know about this until Marguerite got a call asking if I'd be willing to cooperate with an OPC inquiry. I said yes, immediately. When a company receives notice of an OPC investigation, 2 months before closing a deal that is supposed to double its revenue, certain things begin to happen. Priorities shift. The conversations at the executive level change tone. And the people who created the problem, people like Shelton, suddenly become more of a liability than an asset to the people above them. The CTO, I'm told, was the first to understand the math. Shelton had approved vendor access over the objection of the security officer, who had documented his objection formally. That security officer had then been terminated 2 weeks after filing the incident report. The documentation showed a clear timeline. And the security officer had retained all of it, legally, under the terms of his own contract. There was no version of this that looked good for the company if it went to a hearing. The negotiation that followed was handled entirely through Marguerite. I wasn't present for any of it. She kept me informed in plain language. They came in at one number, she countered. They moved, she held. At one point they asked whether I'd be willing to sign a non-disparagement clause. Marguerite told them I would, subject to appropriate carve-outs for cooperation with regulatory bodies, which, given the OPC involvement, they could hardly argue against. In the end, the settlement included full reinstatement of my employment record, meaning the performance-based termination language was removed, compensation equal to 24 months of salary, a contribution to my pension to account for the disrupted years of service, and payment of my legal fees. I also cooperated fully with the OPC inquiry. That process had its own timeline and its own outcome, which I won't go into in detail because portions of it are still part of the public record in a way I'd rather not rehash. What I'll say is that the vendor arrangement was terminated. The access protocols at the company were overhauled under OPC supervision, and the company issued a voluntary breach notification that it probably should have issued 8 months earlier. Shelton left the company approximately 6 weeks after the settlement. His departure was announced as mutual. These departures always are. Bridget, the privacy consultant, had her contract expanded significantly. She now works full-time. My son called me when it was over. He's studying computer engineering, and he'd watched some of this from a distance without knowing all the details. He asked me how I'd known to protect myself the way I had. He meant the clause, the documentation, all of it. I thought about it for a moment. I said, I didn't know something was going to go wrong. I just knew that if something did, I wanted to be the person who could prove what actually happened. So I built the kind of records I'd want to have if I ever needed them. He was quiet. Then he said, "Is that how you've always worked?" I told him yes. I told him that in 22 years in security, the thing I'd learned more than anything else is that the most dangerous moment in any system is the one right before someone decides the rules don't apply to them anymore. Your job, when that moment comes, is to have already prepared for it. He said he was going to start reading his employment contracts more carefully. I told him good. I told him to read everything, especially the parts that seem unimportant. The fine print is where the truth lives. I learned that a long time ago, in a broom closet that used to be a server room, building something I hoped no one would ever need to see fail. They tried to make me the one who failed. They used a clause I wrote myself to find out that wasn't going to be possible.